Hi, I'm Bert True with the law firm True & Associates. Let's talk about the Unfair Claims Settlement Practices Act. This act, which has been adopted in most states, identifies 14 prohibited unfair claims practices for insurance companies when settling personal injury and wrongful death claims. The act delineates 5 prohibited practices involving communications between insureds, the person who has the insurance, and claimant, the person who's injured. An insurance company can't knowingly misrepresent to claimants and insured relevant facts or policy provisions relating to coverages at issue. So they can't lie to you about what insurance coverage you have. They can't fail to acknowledge with reasonable promptness pertinent communications with respect to claims arising under its policies. So they can't ignore you. Failing to affirm or deny coverage of claims within a reasonable time after having completed its investigation relating to such claims is also a violation of the Unfair Claims Settlement Practices Act. So this means they have to give you an answer. Failing in the case of claims denials or offers of compromise to settle promptly, provide a reasonable and accurate explanation of the basis of the action. So they can't just delay, obfuscate and delay, which, as you know, is the way most insurance companies like to handle things. They cannot, in the case of claims denials or offers of compromise, they can't fail to provide a reasonable and accurate explanation of the basis of their action. Like, for example, in denying a claim, they have to give you the basis for the denial. They can't just deny the claim and not tell you why. And they can't not provide you with the forms necessary to present a claim within 15 calendar days of a request with reasonable explanations regarding their use. So they can't, not give you the forms and then say, well, you didn't fill out the right forms. There are also 7 specific claims activities which are prohibited. And these are as follows: not attempting in good faith to effectuate a prompt, fair, and equitable settlement of claims submitted in which liability is reasonably clear. So if the liability, remember, the formula for a personal injury claim, there has to be both liability and damages in order for a personal injury claim to be a viable claim. Liability means the other person, the other driver, has to be at fault, and damages mean you have to be injured. So if the liability portion is clear, then the insurance company has to promptly and fairly and equitably settle the claim. Compelling insureds or beneficiaries to institute lawsuits to recover amounts due under its policies by offering substantially less than the amounts ultimately recovered in suits brought by them. That's also prohibited. So they can't force you to file a lawsuit. Refusing to pay claims without conducting a reasonable explanation is kind of self-explanatory. If they don't, a reasonable investigation. If they don't investigate the claim, they can't refuse to pay. Attempting to settle or settling claims for less than the amount that a reasonable person would believe the insured or beneficiary was entitled to by reference. So, in other words, they can't be unreasonable in trying to settle the claim. So, and they violate this all the time. Frankly, insurance companies violate this on a daily basis because their initial settlement offers are almost always unreasonably low. Attempting to settle a claim on the basis that an application was materially altered without knowledge and consent of the insured. In other words, they can't deny a claimant's claim because their insured lied to them on an application. They cannot make claims, payments to an insured or beneficiary without indicating the coverage under which the payment is being made. So you remember we've talked about the types of coverage under an insurance policy: bodily injury coverage, uninsured motorist coverage, underinsured motorist coverage, personal injury protection, or medical expense coverage. They have to tell you what portion of the policy they're paying out under. A lot of times, here's the thing, this is what the Act is trying to prohibit. Insurance companies will pay out under the medical expense portion, which they're required to do and to do promptly, and there's no determination of fault in a medical expense claim, and then they'll act like, well, that's it. That's all you get. That's a violation of the Act. Unreasonably delaying the investigation or payment of claims by requiring both a formal proof of loss form and subsequent verification that would result in duplication of information. So they can't force you to keep providing the same information over and over and over again. If you've been treated unfairly by an insurance company, it's time to get a lawyer, somebody that knows about the Unfair Claims Settlement Practices Act and can enforce its provisions against the insurance company. Let me know what you think in the comments below. I'm Bert True with the law firm True & Associates. If you have a suggestion for a topic, please post it in the comments below. If you're watching on my blog, you can subscribe to my blog by email. Just click the link below that says subscribe by email. You can also follow this blog using Google+. You can, if you want to discuss something in private, you can click the Google Voice gadget below.